great morning, rather. We're here for a bittersweet reason this morning.
The Fifth Circuit's opinion in Rahimi is really maybe the most prominent, thus at least, Court of Appeals decision applying the Supreme Court's decision from the summer of 2022 in a case called New York State Rifle and Pistol Association versus Bruen. And what was really important about Bruen, and I think why we get the result in Rahimi, is that the Supreme Court said that from now on, the constitutionality of modern gun laws should be determined not based on things like whether the laws, further their stated purposes, whether they save lives, whether they prevent terror and intimidation and coercion, but rather based solely on whether they are consistent with historical tradition, which is a new test for the Second Amendment, and it's led to a lot of sort of disagreement and I think confusion in the lower courts.
Prince Trace, ooh, fancy.
This would be a premium. This one's a lefty.
Yeah, I think even under the historical tradition test that Bruen gives us, and this was the argument that we heard today from the Solicitor General, I think it's correct, one has to look not just for specific enactments that existed in 1791 when the Second Amendment was ratified, or 1868 when the 14th Amendment was ratified, but rather the principles that we get from historical traditions of regulation. And one obvious principle, which has been recognized by many of the justices, including then Judge Amy Coney Barrett when she was sitting on the Seventh Circuit, is that governments traditionally have had the power to disarm those thought to be dangerous. And so I think that this oral argument today, and the way at least it seemed from the questions, the justice seemed receptive to the idea that a person like Zaki Rahimi, who a judge has determined presents a particularized risk of danger, can be disarmed consistent with that historical principle. Now, the government's definition, like what does it mean to be responsible? What does it mean to be a law-abiding? I think really kind of came back to the principle of dangerousness. So the Solicitor General, I think, was very clear that when she uses the word responsible, she doesn't mean it in a colloquial sense about, is the person the kind of person who takes out the recycling once a week or whatever. This is about danger to others. But I think based on what we heard today, I would be surprised if the government doesn't win in one way or another. That is, I would be surprised if the court lets the Fifth Circuit's decision stand as it is written today. And I base that, on the questions and sort of suggestions made not only by the justices who dissented in Bruen and Justice Jackson, who's joined the court since Bruen was decided, but also questions from Justice Gorsuch, Justice Kavanaugh, the Chief Justice, Justice Barrett. I think just putting all of them together gets to 7 justices at least who seemed pretty sympathetic with the government's argument about dangerousness. I mean, this particular provision, again, 922 G8, it's not often charged as compared to some of the other federal prohibitors like the felon prohibitor. I think there's maybe a couple dozen cases a year. So the practical import is huge. I mean, domestic violence restraining orders, very important tool for combating homicide and terror in the context of domestic violence. But, this particular provision is not necessarily the central tool. The court, if it upholds this provision, I think will, in so doing, bless the kinds of laws that all or nearly all states have as well. So that's very important.
The NRA has got to go. Hey, hey. Ho, ho. The NRA has got to go. Hey, hey.
I am also a part of the population and generation that has endured a mass shooting at her school.
So again, going back to the Bruen case, there, the court introduced this whole new test for evaluating whether gun laws are constitutional. And what we've seen in the roughly 18 months since then is enormous amounts of confusion in the lower courts, disagreement between lower courts about the constitutionality of particular laws, and just kind of a general sense of just kind of, I think, unsettled. Whether one likes the results or not, it doesn't look like constitutional law operating very well, just in terms of being predictable and sort of manageable. So I think what we can hope for from the court here is a little more clarification about what it means for a modern law to be relevantly similar to a historical law.